Welcome to the mock Armenian Constitutional Court cases, presented by the World Affairs Council of Austin. We will be examining two moot court cases, the Armenian Church case and the Armenian Treaty case. First, we will review the Armenian Constitutional Court, focusing on its historical perspective and operational framework. Our first case, case number 1, involves the Armenian Apostolic Church as the plaintiff against Nikol Pashinyan, Prime Minister, and the Republic of Armenia as the defendants. This case is significant because it explores the balance of power concerning the separation of church and state, religious freedom, and democratic integrity, as promised by the 1995 Constitution. The factual matrix begins with the, quote, reform package adopted by the Holy Synod of the Armenian Apostolic Church in March 2024, which centralized priest appointments, granted exclusive authority over religious endowments, and allowed the Patriarch to issue binding doctrinal edicts in specific municipalities. In response, Prime Minister Pashinyan's administration enacted a provisional decree, citing Article 73, which mandates the Church to submit the reforms to the Constitutional Court for review before implementation. The Church claims that the reforms are internal governance matters, align with the Constitution's recognition of their special historical role, and are essential for protecting Armenian cultural heritage. The state counterclaims that the reforms exceed constitutional boundaries, threaten the state's secular nature, and violate the guarantees of equality before the law. The legal issues center on whether the reforms infringe on constitutional articles regarding freedom of religion, equality, non-discrimination, and whether the, quote, special status clause authorizes legislative power, along with compliance with procedural requirements for amending religious statutes. The Church argues the reforms promote equality of faiths, have no legislative effect, and centralized stewardship aligns with international obligations. Further Church arguments include historical continuity through Article 8, the doctrine of internal autonomy, and protecting sacred assets through centralized endowments. The state's arguments include a procedural defect by bypassing parliamentary ratification and concerns over the potential for theocratic governance, which violates laïcité. The state also highlights the risk to minority rights if the Church gains legislative power and potential violations of international human rights obligations concerning freedom of belief and equality. The court must interpret the, quote, special status clause, determine if the reforms constitute legislative power or internal governance, assess procedural compliance, and balance competing rights like freedom of religion versus equality. The conclusion of case number 1 will hinge on how the Constitutional Court weighs the Church's historical role against the rule of law and the secular principles of the Republic. Again, case 1 features the Armenian Apostolic Church as the plaintiff against Prime Minister Nikol Pashinyan and the Republic of Armenia as the defendants. The rules for this moot court allow 2 attorneys per side with 20 minutes each, totaling 40 minutes per side. The plaintiff can reserve up to a 5-minute rebuttal. The point of error is whether the current church reforms are unconstitutional. Resources for the state's arguments are available in Pashinyan's blueprint, Legal Perspectives on Reforming the Armenian Church. Resources for the church's arguments are detailed in the Armenian Church Answers. This marks the end of the overview for the first case. Here is an illustration of the Armenian Church versus the state. Next, we move on to the second case. Case number 2, the Armenian Treaty Moot Court, involves John Doe, an Armenian citizen, as the plaintiff, versus Nikol Pashinyan and the Republic of Armenia as the defendants. The point of error in this case is whether the current United States-mediated peace treaty between Armenia and Azerbaijan is unconstitutional under the Armenian Constitution. This dispute centers on whether the peace accord, intended to end decades of hostilities, compromises constitutional provisions and the supreme law of the land, requiring the court to determine if the treaty violates the Armenian Constitution. The plaintiff, John Doe, argues for the supremacy of the Constitution, claiming the treaty conflicts with territorial integrity and that fundamental changes require a constitutional amendment with a public referendum. Further arguments from the plaintiff cite improper delegation of sovereign power to a foreign state, failure to observe the principle of legality, and infringement of the right to property. The plaintiff also argues that the treaty contravenes incorporated international law and includes a procedural defect due to the absence of a required public referendum for national territory amendments. The government, represented by the defendants, argues that the treaty is a legitimate exercise of foreign policy authority and, as a duly ratified international agreement, enjoys constitutional status under a national security exception. Additional government arguments include that the treaty implements, rather than amends, the Constitution and adheres to international law principles like pacta sunt servanda, justifying the actions under public interest and procedural regularity. This image serves as a visual break. Another visual break. A final visual break before the conclusion. The court must ultimately decide whether the Constitution serves as an immutable foundation against foreign settlements or must bend to geopolitical exigencies for the sake of peace and national survival. Thank you for viewing this video on the mock Armenian constitutional court cases.